Carolyn wants to be included.
Oh, sorry.
Okay. Okay, we'll get started. Good afternoon, everybody. I'm Drew Jitomer, on the faculty here at the graduate school. I want to welcome you all. This is the first brown bag of the year, and we've tried to expand the brown bag a little bit. So we have a few different strands. This work is being facilitated by a number of graduate students. The overall plan is being supported and facilitated by Louis Leyva. And so thank you, Louis, for all the good work in bringing all this together. But we've got some strands in a general policy area, broad area there. We're also trying to bring in some speakers in the measurement statistics area, as well as the long-established learning, teaching, learning sciences program. So we hope to basically have talks for the whole year, and we've got a nice program, I think, lined up so far. So welcome all. Today, we are honored to start this off by having Bruce Baker present to us on an extraordinarily timely issue, and this is around charter schools, which you know is having a profound effect on American education and how resources are being allocated, where it should be going, and the general political discourse around teaching. Bruce is just has done a tremendous amount of work and been tremendously provocative in examining lots of the current policy initiatives that are taking place in education. So thank you. You need to, also this year we're going to be streaming these live. So, and they will appear not only live, but they will be recorded on the GSE's YouTube channel. If you didn't know we have a channel, we do. So Jen and Jamie had that work up, and so thank you for doing this. So the recording will be archived and accessible to all later in the afternoon. What that means is that while Bruce will be getting the camera and mic, whatever else happens here is also going to be captured on broadcast and recording. So don't say anything that you don't want your mother to hear. No streaking, nothing like that. And we should be good to go. Okay. Thank you.
Thanks. But I encourage you, see, I guess I've got a monitor here so I know where it's I encourage you, though, don't hold back. Speak up. Let's get a conversation going on some of these topics. I did a couple of brown bags last year on a number of topics. A lot of you do know me as a kind of a numbers geek, a public policy numbers geek, school finance, economics, a bit guy. Another area in which I work, there are very few numbers in this presentation. So I will give you a chance, you know, if you came here to hear me talk about numbers, data in the policy context and really have absolutely no interest in where we're headed from this point on, I'll take a moment and let you finish your pizza and back up, because here we're digging into legal issues. What I'm going to talk about today is based on some education law work that I've done with a couple of colleagues, both of them have their law degrees as well. But I've been writing in the area of education law and policy, specifically pertaining to the kinds of governance issues I'm going to talk about today, and also pertaining to, turned out when I went into the area of school finance, I did not realize the extent to which a number of times and depth of complexity at which, you know, all of that stuff would eventually end up in legal litigation. So I quickly became very immersed in issues around school law. Spent a great deal of time studying school law and eventually writing about school law. And I teach the school law course here. Thankfully, my office was next door to one of the leading national authors on school law issues while I was at the University of Kansas, which was really helpful. Kind of go to him and learn. And also kind of stepping back from the legal questions that are posed in this presentation, there are broader questions of there are broader ethical questions. One of the big issues that we have to ask ourselves, it's kind of a theme in the school law course, the sales pitch for school law spring semester course offered on, I think, Monday evening at 7:40. One of the questions I always kind of pose to my students is, I want them to think about the difference between doing that which is minimally legally permissible and that which is the right thing to do. It's really important to think about, well, what is it that we can get away with? Really to think about what is it that we should do versus what is it that we can get away with. And in this case, I'm going to pose that question in a slightly different form. This title is based on the law review article that I have coming out with Preston Green, who is formerly of Penn State University and now at the University of Connecticut, who is a scholar of education law, and his doctoral student who came out of the Ohio Attorney General's office and finished his doctorate at Penn State with Preston and is now the education law professor at Montclair State, Joseph Olawole. Joseph and Preston and I frequently have these kind of poking and jabbing debates and discussions over what we think might be the most volatile issues to bring up. And then we try to figure out how to frame law review articles around them. This actually started, this concept started as a blog post that I wrote maybe about a year or so ago, which has since had about 6,000 or so hits and downloads. Around this question of where exactly the charter schools fit on the continuum of publicness, privateness. There are those who want to jump right in and say they're necessarily private schools. There are those who want to jump in and say, no, they are public charter schools because the word public is there, they are necessarily public schools. And we've only developed a better picture of where they really fall in by watching the case law and the legal arguments play out. Because publicness and privateness delineations do matter in making legal determinations. Actually, really nice framing of it. I thought it was interesting. I managed to get an advanced copy of Diane Ravage's book about a month ago, and I was reading this paragraph. I was a little upset that she kind of stole our title here, although she does cite it back to our paper. It's nice. But she points out on page 163, charter operators want to have it both ways. When it's time for funds to be distributed, they want to be considered public schools, but when they're involved in litigation, charter operators insist they are private organizations, not public schools. And then she goes on to discuss actually a fair amount of the case law that we parse in our paper. I didn't bring enough to go around the room. I brought a copy of the law review article we have coming out in the Emory Law Review, which is a pretty good law review journal, which is called "Having It Both Ways: Charter Schools, How Charter Schools Try to Obtain Funding of Public Schools and the Autonomy of Private Schools." And I actually brought, for those who would prefer the quant geek side of it, I have an analysis of data on public and charter schools in New York City and Houston and the equity consequences of moving towards a portfolio model. And these things really all fit together in important ways. So, see, I'm not going to be on camera like 90% of the time because I like to move around, but I'll come back and say hello. Just wanted to kind of throw some of the rhetoric that's out there that, for those of you who follow the debates and the blogs and the public policy discussions of where we should be going in school choice programs and charter school expansion, we hear terms like pushing portfolio models of schooling, that we should do away with the notion of a traditional urban school district and replace it with instead of a school system, we should have a system of great schools. That we should let whatever providers into the mix of schools in the city and let kids choose and parents choose among the best providers. That's pitched often alongside of this phrase sector agnosticism. We really shouldn't care about what types of provider, online for-profit, not-profit, government-operated. We shouldn't care what type of provider provides the schools as long as they're great schools, with some ambiguity about the determination of what greatness actually entails. Maybe a little. And then this notion, which this notion of relinquishment, which is the one that I guess kind of bothered me more because it suggests just succumbing to these pressures and handing over control, this notion that we need to relinquish our schools to these alternative providers, that good public officials are those that don't feel the need to control and operate their own systems. They relinquish it to a portfolio model. This is actually one guy with a law degree in the mix who was part of the Yale Law Clinic on education policy a number of years ago when I spoke to them on school finance issues. So he's a Yale law grad. Interesting character, but this concept is I've written about it elsewhere. The underlying assumption is, and this is the trade-off piece that I want to set up as the theme for this presentation, the underlying assumption that the goal is for some good, great schools or good outcomes. And that any other trade-offs that may exist, if they exist at all, are innocuous. They're benign. That there's nothing else we should worry about as long as we're providing the choice among great schools. But there are some issues that come up that may be not measurable in terms of your traditional test score outcomes, graduation rate, persistence outcomes, things that are not necessarily looked at in studies of effectiveness of charter operators or whatever. Just to go back to definition stuff, if you look at the National Alliance for Public Charter School definition, they say charters are independent public schools, from which a lot of people who enter the debate say, well, they're public schools. And in fact, if you look at a lot of state, the definition of a charter school is defined independently by each state. And in a lot of states, the language will look similar, that this statute provides for the establishment of independent public schools. So the word public will be there. The courts haven't always decided that the use of the word public in that phrase is necessarily meaningful in a legal sense. We'll get back to that. Just to give you an idea of what we got going on here, the publiccharters.org website, they put out a charter market analysis. It's supposed to be on an annual basis. I'm not sure that they've really updated it every year. I've done some of my own additional work to pretty quick to run these numbers. On what is the charter? These are the growth numbers. On the charter market share in cities that have the highest charter market share. Market share being defined in terms of the percent of children who are enrolled in charters out of the system as a whole. So in New Orleans, it's 76% of the kids. Detroit, 41. DC, 41. Kansas City, 37. Pretty high share of kids are enrolled in charters in these cities. We know that generally there's much, and these high charter market shares tend to be in larger urban districts that have higher minority concentration, higher poverty concentrations than the districts around them, which on average have much lower charter concentrations. And this kind of comes back to us at the end when we think about some of these trade-offs that I'm going to pose to you that are around these legal and constitutional and statutory issues. We're creating potentially serious trade-offs around legal rights with the way we've decided to move forward in the structuring of charter schooling. It's not necessarily how it has to be done, but with the way we've done it, we're creating some trade-offs, and we are disproportionately passing those trade-offs onto populations in certain locations and certain types of populations. We're asking some families, parents, and children in some communities to trade off rights and privileges at a higher rate than others. And therein lies kind of the broad kind of ethical concern. That's where we're going from here. That's exactly what we're going to dig into. And again, it's not necessarily the case that those rights would have to be traded off, but we're going to see that the charter policies have been structured so that they don't. We're moving more in a direction of permitting the trade-off as opposed to restricting it. Just to kind of go over the governance continuum, and then I'll do this in a picture. We have traditional public schools, district-operated schools, governed by local elected boards or appointed boards of people who are public officials. We have government-authorized charter schools, privately authorized charter schools, and I'm going to lay this out in a picture in a minute. Publicly subsidized private schooling takes us further down the continuum to tuition-subsidized private schooling. But even if you take New Jersey, for example, parents who would send their kids to your traditional kind of private, independent, non-religious, or even religious private school are getting a textbook subsidy and a transportation subsidy in most districts. So there's even some public subsidy for the vast majority of private schooling in New Jersey. It's not fully off the public dime. And then homeschool. In some cases, in some states, there are subsidies for testing and curriculum material on homeschooling, but we're kind of moving from that which is directly government operated down to that which is, you know, as kind of private and independent of the government as possible, and charter schooling running this range in between. And that's the issue, is that all charter schools don't land at the same point in that range because it's a really messy picture. In New Jersey, it's a more straightforward picture than in many other states. But we have state government up here. And in New Jersey, it is a branch of the government itself that does the authorizing of charter schools. Now, in the last few years, they've brought in teams of private citizens to review applications. And whether you're anyone who works in a public school district or is part of a local elected board of education or works at any other public or government institution is an agent of the state. And one of the first lessons in school law, talking to teachers who are mostly out of public schools. You are agents of the state. You are part of an organization that is a state actor. You are actors of the state. Your actions operate as, you know, this agent of the state. But you know, if you're a private entity that is working for the state on a particular project, you may not be. The State Board of Ed authorizes charters in New Jersey. The State Board of Ed is an agent of the state. The Board of Ed and the Department of Ed are state employees that are agents of the state. The Board of Ed are appointed officials that are they're public officials. Their meetings are subject to open meetings laws. Their records are subject to open records laws. They're the ones who authorize charters in New Jersey. But when they authorize a charter in New Jersey, that charter establishes a governing board of its own. That is a governing board. It's like a governing board of a nonprofit organization. They're not elected officials. They file an application. They list who their governing board members are going to be. They get approved to govern this charter school. And New Jersey has stepped in its charter school law and defined that there are certain requirements of those boards that govern charter schools that will necessarily be similar to if they were public officials. They are subject to open meetings laws. It's not specified whether the same open records requirements apply, but they're subject to most of the requirements as would be an elected local board of education in New Jersey, but not in every state. And that governing board might just run its own show. You get a mom and pop group, you get a group of people from a community to establish a board, apply for a charter, you get a charter and you run your own school. Or it could branch out. They could say, well, we want to actually hire Eva Moskowitz Success Academies to come in and run the school. Or we want to contract with K12.com or something to deliver the curriculum. Or we want to contract with some other private provider, nonprofit or for-profit, KIPP or Imagine Schools. There are a number of management, for-profit management companies out there. There are a number of nonprofit management companies out there that could become the entity that actually manages the operations of the school. So that instead of the students under discipline policies and teachers under contract policies having their agreements with this board, they may have their agreements with a private management company. And that changes a lot in employment law. And it may actually change a significant amount in terms of student disciplinary policy requirements in the kids' constitutional and statutory rights. So the more we stick in these different pieces, we can have in New Jersey, your governing boards of charters have certain requirements treating them as public officials, but they may still contract out a private management company, which is the entity with which teachers and other employees hold their contract. But of course, in New Jersey, there are still more precise instructions as to what rights do teachers have in union organizing and pension plan participation and so on, even if their contract is with a management company. But I encourage anyone who has the time to spend and wants to, I encourage you to to request copies. You know, if you're interested in this topic, I'd love someone to just throw a trial balloon out there for me and ask each of the charter schools to provide you copies of their entire contractual agreements with their staff, and then get back to me as to how many of them will respond that those are not public records but private proprietary agreements, which would then have to be litigated in court to see, you know, which the court thinks they are. I've already, anecdotal evidence in New Jersey and other official evidence through the courts elsewhere suggests that many are going to shield those as private proprietary documents among the private management companies. Certainly there are administrative contracts, in many cases they're teacher contracts. They are not posted on the public employees website, her website that has all the negotiated agreements for every public school district. In New Jersey, the charter contracts are not posted. So it's one delineation. Move further over here, we could, and I'm going to toss some of these things out there by comparison as we get. We might have directly subsidized private schooling. Most of the court cases that have vetted that have decided, you know, that this entity is privately managed, it's privately held contracts. We may subsidize this institution, but it doesn't mean that they're subject to state laws around public records, and they're not subject to constitutional rights of children around due process for dismissal and so forth. There's no private school, even if publicly subsidized, and I'll go over the case on that, tends to be treated as a private school. A separate issue is this whole kind of convoluted process of establishing tuition tax credit scholarship programs, which establish a non-government entity to collect contributions which are granted a tax credit, where that entity can then hand out those contributions for the purpose of these voucher scholarships. Just to show you, we've got this kind of evolving complexity to the education system, and it has implications for kids and teachers' rights that we shouldn't just blow off. You know, we may decide, okay, I've looked at the implications, I've figured out how to regulate them appropriately, I've figured out whether they need regulating, and now I'm willing to move on, but we need to at least consider them. Government entities and officials are treated differently than private entities and officials under federal and state constitutions and statutes. That's kind of the overarching issue. There are limits. If you look at the purpose and design of our Constitution, the rights that are laid out, the protections that are laid out in our Constitution are protections of us against action taken by our governments against us. That our government shall not infringe on our rights in terms of due process, in terms of freedom of speech, and so on. So it's not that, you know, a private entity can do that all it wants. Government officials cannot. Government, and then under certain state laws and statutes, government officials are commonly subjected to different types of regulations, sunshine laws, open public records, open meetings laws, and so on, and that's why the courts are having to parse, go back to that messy picture before and say, in which of these little bubbles are these officials, are these people government officials, or are they private citizens, or members of some private entity that should not be subject to public law? And let's just see, if you dig into the legal cases in this paper, the way that an individual is able to challenge the deprivation of their constitutional rights by a government entity, to be able to say, my school district has taken disciplinary action against me that has caused me harm in terms of my educational record, my future opportunities, and they've done it simply because I was exercising my free speech rights. The ongoing fun case over that is the one in Easton, Pennsylvania, over the middle school age kids who wanted to wear the I Heart Boobies bracelet. Right? I mean, the student First Amendment cases are just wonderful fodder for discussion in the school law class, and for mock trials with middle school and high school kids. I actually got into the school law stuff doing as a mock trials coach in New Hampshire like decades ago. The way that, you know, kids and their parents are able to make the challenge of the government institution's violation of their rights is often by way of going through this threshold of the Section 1983 of the U.S. Code, which is it's a piece of civil rights legislation that essentially declared that individuals whose rights are violated by their government, be it their state governments or the federal government, it basically declares that they have a claim, they have a cause of action. If you don't have a claim that your government has caused you these damages, then you can't get to the substantive question. You have to get past these threshold questions in a legal case to be able to evaluate, did they actually cause you harm? Did they actually do you wrong and violate your rights? Your opportunity to bring many of these types of suits against your government, be it state or local government, state or federal or local government, is brought through this Section 1983 of the U.S. Code, and Section 1983 specifically establishes a cause of action for deprivations of either federal constitutional and statutory or state, right, among, if the institution is considered to be a state actor. Right, because a private institution doesn't have to give you due process before they boot you out the door. A private institution doesn't have to consider whether or not you had free speech rights to wear a certain symbol as an employee or even to participate as a student. A public institution can't, for example, compel you to recite something, but it's question. A private institution might be able to compel oaths among children and honor codes that must be spoken, but that's why we can't. In a public school, you can't necessarily compel the speaking of the Pledge of Allegiance because you have a right not to speak as much as you have the right to express yourself within certain limits in free speech litigation in schools. Section 1983 provides us the pathway to these rights, and it only applies to state actors. So that's where the courts have been kind of litigating this question of, which schools count as state actors, which entities count as state actors. Also, the big thing that's come up lately is which labor laws apply. In privately managed charter schools, do teachers and other employees have the right to organize under state laws governing public employees, or are they governed by the National Labor Relations Act, which is a federal statute governing private entities? Going back to Section 1983, here's the actual wording of it. Every person who, under color of any state statute, ordinance, regulation, custom, or any usage of any state, territory, or tradition subjects or causes to be subjected to within the jurisdiction of deprivation of rights. So if your government deprives you of rights, you have a cause of action. You don't have a cause of action, you're done. Even if someone has really, if you don't technically, legally have a cause of action to get you past the threshold and into trial, you're not going anywhere with your argument, even if you've been wrong. Or at least have an argument that you've been wrong that you believe should be dead. So one example, which actually comes back at us in the charter cases in federal court, is this a case where, and you can see the parallel based on my organizational picture, vocational counselor and teachers brought suits claiming that a Massachusetts private school served maladjusted, this is the phrasing from the actual legal claim. I worded it differently myself. So, yeah. You got to put it in time frame. Maladjusted said fired them in violation of their First, Fifth, and 14th Amendment rights. Now, it's also possible that these days, if you're speaking out about wrongdoing by the organization, that there might be state whistleblower statute laws. It could be a totally separate issue, but here they're saying they've been fired for speaking out on certain issues and that they've been denied due process. The 5th and 14th is a due process piece, and the freedom speech piece is the first. Almost all students, and in this case, they felt comfortable at least throwing the legal argument out there, even though they knew it was a private school. It was a private school where all the students were referred by city agencies, 90% of the money was public. Therefore, they essentially were arguing that, in effect, this private school is a state actor. And therefore, they should have these rights. The court did not buy the in effect argument. The court reasoned that a school was not a state actor. You know, the ultimate issue in determining whether a person is subject to suit under Section 1983 is the same question posed in cases under the 14th Amendment as the alleged infringement of federal rights fairly attributed to the state. They decided that had they agreed that it was fairly attributed to the state, the actions of the heads of this private school in denying the rights of these teachers, that could then be analogized to any private entity that is doing the public's work, building roads, bridges, and so on, and that they didn't want to, the court did not want to make a decision that went that far. But that comes back at us in recent charter school litigation. Bottom line these days is that unless it's explicitly laid out in state charter school laws, it is not assumed that the boards of charter schools are public officials. It's not assumed that the management companies must comply with public employee labor law. It's not assumed that students or teachers have the same rights that they would in a district school. Doesn't mean they don't. Doesn't mean sometimes it's not a good job. I mean, it's like, you know, if you're working with teachers and they're kind of haggling over, well, what's the best decision for me? This isn't, you know, this stuff isn't all a kiss of death. It's just that these are trade-offs. Sometimes working in a private school is totally, I had a great job teaching in a private school in the Bronx a number of years ago. It was a wonderful school. But you recognize that along with the environment and reasonable pay, I had a great benefits package. We actually had a union negotiated contract, even though it was in a private school. It wasn't attached to any national union. You know, but we wouldn't have been guaranteed the same due process on dismissal. We would not have a right to claim a violation of our First Amendment rights if the school acted against us and dismissed us for doing something that we thought was speaking out. And should be protected because it was a private entity. And it's just important for pre-service teachers or even teachers working in the field and making these decisions to know this stuff. And in charters, they might be trading off the same thing unless the state law explicitly says they aren't. But they might be trading off the right to organize and unionize, or at least their right to establish a collective bargaining agreement might be governed under federal laws related to private industry rather than state laws governing public employees. An area potentially to be litigated is the extent to which in some states the charter employees can be included within the public retirement system. I'm going to skip over these frameworks, but I had laid out these kind of a whole framework thing. I'll make the slides available to talk about governance, finance, disclosure, employees, and student issues. It's kind of a chart that summarizes the stuff I've already talked about. And I also go further in talking about how that relates to voucher and tuition tax credit programs. The quirk with tuition tax credit programs that came up in a really interesting case a couple of years ago is that instead of the government directly providing a subsidy to private schools, the government allows a tax credit for corporations that give to this state-established private entity, which then grants the money. It's mathematically, it results in the same effect on state-wide budget. And the cases that have been brought about voucher programs were cases challenging whether or not the government could directly allocate funds to religious institutions, the Cleveland case, the Zellman case. And it was brought by taxpayers on the grounds that there's this, you have to suffer damages to bring a suit. That's another threshold question. And the damage you're able to argue about your government providing direct support for religious services is it's an objection of conscience as a taxpayer. That because this is in opposition to your beliefs and it's specifically related to religion, we can tie that back to a First Amendment claim, and that you suffer damages as an objection of conscience regarding the use of your tax dollars. And the substantive question had to be then whether or not the system that they set up in Cleveland necessarily constituted a state endorsement of religion, and the court decided it didn't, so the court let the voucher system pass on that basis. So it was neutral of religion, it just so happened that most of the money went to capital. The fun case that came up a few years ago in Arizona was regarding these tuition tax credit programs. and whether or not, and the question ended up being whether or not taxpayers even have a similar right to challenge those policies. Can they get past the threshold question that it is their taxpayer dollars being used to subsidize this alternative service or religious service? And in fact, the court decided that the taxpayers didn't have standing. They couldn't show that they themselves were damaged by this circuitous approach to getting the same amount of money to the same place. So these little kind of subtle technical issues matter. So they couldn't even get the substantive question addressed by the court, which is whether or not tax dollars were being disproportionately used to support religious services, because they couldn't, those who brought the case could not be declared as legitimate to bring the case. So if you can't get past those little threshold questions, then you can't answer the bigger policy questions. And in fact, so we kicked around for days, is there anyone then who would be a legitimate plaintiff who could get past the standing question in those cases? And we couldn't think of it. I kicked it around with legal scholars far better than I. But they're not legal. I feel like I'm depending on it. So teacher rights issues. What we found in the early cases, and interesting thing here is the charters do lose most of these cases. They're declared in a lot of these cases as being sufficiently state actors so that they should not have deprived these individuals of rights. But in later cases, the tide has shifted a little bit because the diagram I had up before is getting a little more complicated. We've got more layers of privateness plugged in. We've got more charters not establishing their contracts directly between their boards of directors and the teachers, but through the management companies and the teachers. Now all that stuff has to be relitigated. But what's consistent here is that every time around the charters go for the, let's kick the case out at Section 1983. That the way that the threshold question is, here the teachers are saying that they are being let go on the basis of what should be protected speech, but it's only a government entity that can that would be restricted on letting you go on the basis of protected speech. A private school can dump you on saying anything that's disagreeable with the mission, and the question is, can a charter school do the same? Well, at least the charter school argued that it could, but the court decided that the charter school law in that state contingent, sufficiently defined charter schools as public schools. The Ohio courts have been fairly consistent on that point, even though Ohio has one of the messier governance structures of charters. They did the same on a public records law case. This other case, the teacher led the principal and board terminated in violation of the First Amendment. The charters moved on the basis we're not a state actor. The court denied the motion on the grounds that the New York charter statute provides that they are public. So they took the word public as meaning something in the broad opening phrase. The New York court did not do the same on bidding requirements for outside contracts, though. They decided that the charter schools did not have to comply, if I recall, with bidding rules that a public entity would have to comply with. The big one in federal court that latched on to that Rendell Baker case is this is a teacher rights case and this one's worth reading. It's Kavanaugh's case that came out of the Ninth Circuit. It's only made it in federal courts. We go from the federal district court to the circuit court to maybe an appeal to the U.S. Supreme Court. We're not there yet on this. But the Kavanaugh's case came out of the Ninth Circuit and also involved a teacher who argued that they were subjected to damages and loss of liberty in pursuing further employment, and as a result of, well, in fact, really they were just trying to make the claim regarding the damages they suffered at the hands of what they were arguing was this public entity, a state actor. The Ninth Circuit really relied heavily on that Rendell Baker case, which I dissected a few minutes ago, where you had this special institution in Massachusetts that was 90% publicly subsidized and had all public, had mostly publicly subsidized kids, but the teachers were contracted by this private entity, and to decide otherwise would have, road contracts and everything else involved. They said Verizon would be a state actor though only if there's such close nexus between the state and the challenged action that seemingly private behavior may be fairly treated as the actions of the state itself. So to the extent that we can say that what Horizon Learning, which is a fairly big management company, a charter school, to the extent that Horizon Learning was acting as a branch of the state, then we would treat it as a state actor, and this teacher would have the rights of a public employee. But to the extent that it's not, and we don't, the court decided if the nexus was not so tight, at least regarding employment issues, that this teacher had no cause of action to bring. They couldn't bring the case. We couldn't address the substantive question, at least in this way, because Horizon Learning wasn't state actor. Other, we move into these labor relations cases, which are now emergent. The ironic one to kick this off is Cesar Chavez Academy refused to let their teachers unionize. Struggling a little with that one. It was Michigan, it was Detroit, I thought it was Chicago. Union filed a petition. The management company argued that they don't fall under public employee laws of the state of Michigan. They should rather fall under the National Labor Relations Act, which cuts things differently. I got a contrast slide coming up. Similar cases bubbled up, in Chicago, where the National Labor Relations Board is the one that stepped in and made the initial determination that it would exert its authority under federal private sector labor laws. Academy administrators agree that teachers have a right to organize, but they don't want to do it under Illinois public employee guidelines. They want it to be done under federal guidelines, which, I'll lay out the differences. And as a result, in many cases, like in Philadelphia now, NLRB is just governing any disputes over organizing teachers in charter schools. Probably a ripple effect across other states as well. So the Illinois example would be the state permits public sector employees to organize through this card check process. The majority of employees sign an authorization form saying they want to be represented, whereas the NLRA permits the employer to petition to say that they have to have a secret ballot. Illinois subjects employers to public entities have to abide by binding arbitration. So you get an arbitrator in there and they make a determination, and theory supposed to suck it up and deal with it. Many states have no strike provisions on absolute no strike provisions on public employees. The NLRA doesn't impose requirements like binding arbitration, but on the flip side, they permit more aggressive actions unless otherwise prohibited. So a state would have to now step in and include in its charter laws something specific about no strike and or no lockout for charters if it's considered otherwise, if they're governed by NLRA instead of by state public employee laws, which state legislatures could do, but for it to be there, they have to take the proactive step. Children's rights issues are also emerging. Again, kids, the same issue with kids, if a kid wanted to challenge as a violation of their free speech rights the fact that their charter school requires them each morning to stand up and say a particular oath of loyalty, or they could challenge that as a violation of their First Amendment rights. They'd have to do that by way of Section 1983. The charter school would then say that our management company has established a disciplinary code of conduct with the students that they've signed. It's a private agreement between parent, student, and management company, and the company imposing this disciplinary, the entity imposing this disciplinary requirement on these kids is a private entity that isn't subject to 1983 and therefore not it doesn't matter whether they deprive kids of First Amendment rights because a private entity can't. So, in this case, it was about the application of IDEA, which is somewhat more straightforward because it's not just as pertains to public entities that are receiving public financial assistance, but also the court rejected the charter school's notion. The charter school still went the Section 1983 route. and the court went against them on this Philly case. There's an interesting, this is a California court then, not a federal court, that recently made the determination. You got to really read all this stuff out. Again, I encourage you, take the school law course in the spring. I'm jumping over lots of random crap, which actually is rooted in a kind of a broader, better organized than this framing of school law. But in state court, and states have their own kind of constitutional due process requirements and oftentimes have statutes and regulations regarding student dismissal. In New Jersey, it would appear that this can't happen. The declarations about student dismissal under the charter statutes link back to the specific laws pertaining to dismissal in public schools, but it does hinge on whether a dismissal is a dismissal. What is it? So, if a dismissal is merely an obligatory transfer, then that may not be a dismissal, and the student may not have a due process right to fight it. And that's kind of where the court went in this California case. That this student who had ADHD was dismissed from this charter, and the court reasoned that this wasn't really a dismissal or an expulsion, but it was letting the kid go back to, because this was a model of choice, it was a school of choice, it was a privilege, not a right to attend, and the kid could go back to the public district if they wanted. So they didn't feel there was any deprivation of rights caused by this dismissal. It wasn't, but that raises a question when you're in New Orleans and 76% of the student capacity is in charters. Right? Well, what happens when you've turned over the majority of your school system to schools that want to operate on a similar model? To what extent are we constraining choices and altering the distribution of rights? Other issues that have come up is, well, if you want to argue private from that standpoint, how does that then relate to these funding issues? There are a number of fun cases about this, but most of the big ones were vetted in the late 90s when charter statutes were first established. But there's some fun issues around the related kind of issues on voucher cases in Louisiana and Florida. A lot of state constitutions make specific reference of the use of public financing for the public education system or for the provision of a uniform system or a thorough and efficient system of public schooling. So to the extent that you're not public or declare yourself not public, then you're vulnerable to this challenge of, well, then you don't have to follow these rules that pertain to public institutions. If our Constitution says that that the financing is available for public institutions, maybe you shouldn't get that either. The Louisiana case over vouchers to privacy in this past year in state court addressed a very similar question, that these certain tax dollars are to be used for the purposes of subdivisions of the public system of schooling, and the court decided that the allocation of those same funds to the private schools did not constitute, that was an unconstitutional use in Louisiana. Georgia was a more convoluted issue where the state had set up a board that could decide that we can put, someone applies for a charter and then the state board approves that charter to be put over here in Gwinnett County. And when the state approves that charter, then Gwinnett County must pass along the funds to that charter. The local board gets no vote, right? So we have some of that same debate, obviously, going on in New Jersey. But in Georgia, the Constitution said that county boards of education were the ones who had exclusive authority over the distribution of school funds. And Gwinnett County brought a successful case against the state on that program, but then a heavily financed campaign to change the Constitution resulted in change. And then there was in Florida, the allocation of vouchers for private special ed schooling and other scholarship programs led to this challenge that the provision of funding out to these other entities to provide services violated the uniformity clause of the Florida Constitution. That was the private entities, not charter schools, and that was one. Most of the charter school cases that were vetted very early on, and you can read these in the paper. Anyone who wants a copy that can't get a hard copy here, just email me, I'll send it to you. or we'll post it. Maybe we'll just post it to the YouTube video. In Michigan, 97, this was like charter school statutes were first being adopted, and people were challenging, citizens of local public school districts were challenging, whether or not the funds could be diverted in this way. In Michigan, the court decided they could, on the basis that these schools were sufficiently public. In Colorado, California, and Ohio, they used slightly different reasons. Ohio's got the quirkiest system. In Colorado and Michigan, it was based on the fact that there was sufficient public accountability around these systems to call them public for purposes of receiving funds. But in Ohio, it was largely based on the fact, well, but there's accountability in the sense they have to take the tests. Not that they're directly governed, because in Ohio they're not. In Colorado and Michigan, they were governed by state entities. In Ohio, a private think tank like Thomas B. Fordham Institute can authorize charter schools to set up as a neighborhood. So they don't have that same line of reasoning to apply that exists in Colorado. And I don't know if that's newer though. I have to check and see what the governance was. Although this is 2006. So, I'm gonna skip over some of this random stuff at the end. We can get it around. I had some figures that I was going to talk. But we've gone kind of long here, and I threw up that first figure. I'm going to go back to it. I couldn't do it at all without numbers. But my kind of thoughts are, there are important, legitimate, serious. There are sector differences between being truly private, between being these kind of quasi-private configurations that have emerged in charter land, and being a government-operated school. There are significant differences that we're seeing emerging in terms of student rights, in terms of teacher rights, and a really important caveat here is no uniformity to this. Totally varies by state policy context. Even the federal arguments about federal rights are contingent upon state policy definitions. But there are differences, and charter operators, this is, whenever you hand, how it is even in school boards and school districts, as soon as you hand stuff over to your legal team, it's like a sporting debate over what's the cleverest argument we can make to not let them get past the threshold question so we never have to bother with the substantive argument. And that's just legal strategy. It's just the way it works, and that's why we see, all of the attempts to, knock it out at kind of the Section 1983 point. In some cases, with the increasingly complex structure of charter organization, we're seeing winning cases, like in the California case regarding student due process, or in the Evans case, which is only a couple of years back, regarding the teacher contractual rights. We're shifting larger and larger shares of kids into charter schools. And even if there exist some measurable achievement benefits in the aggregate, this is not a benign choice. We can't just say because this particular lottery-based study showed this measured student outcome benefit that it's necessarily, on that one metric, the best policy decision. If we're ignoring entirely that we may be obligated, by making that a bold policy decision, that we're going to turn the whole system over to that, we're saying 76% of we're saying, yeah, you don't have to choose these schools, but they happen to be the only ones available. And going back to New Orleans, actually, and Kristen Burris wrote, I'll bring up the picture. Kristen Burris wrote this wonderful piece in Harvard Ed Review about what happened post-Katrina. And the point is, immediately during and right after Katrina, the vast majority of families with kids moved to Houston and a couple other places. There's some really great studies by sociologists, kind of mixed sociologist, economist Scott Immerman, that looks at the distribution of kids and outcomes and effects in Houston over that period. Kristen Burris does more of a kind of a qual piece. I'm looking at what happened in New Orleans, and this is New Orleans in 2000. This is New Orleans in 2010. The yellow triangles are charters, and essentially, what happened is they just never, in in the 4 or 5 years following Katrina, they never put schools back in the lower ninth ward and a couple other places, and just created a scenario where kids and families couldn't come back to certain areas of town. And distributed opportunity in a way that's very differently distributed than it was before, albeit we can question the quality of the opportunities as they were distributed before. They did actually also put in a significant amount more money in more recent years, so that's gone up, but they've redistributed opportunity by design as a function of in response to national disaster. And now we got 76% of the kids in some form of charter, which it's not that all charters are going to go out and do the extreme of what they can do. Just like not all private schools are going to do that, right? You know, it's that we're setting up a system that permits that, and is that necessarily good? And I was happy when I tweeted out that piece about the California case decision that the court saying charter dismissals don't require due process. One of the first people to respond positively to that was the head of one of the biggest charter organizations in the that, you know, saying that that's awful. You know. So, you know, this is not to say that everyone, you know, a lot of good people running all sorts of different types of schools out there, but we're not, as a result, paying attention to some of the things that can happen. So back to my closer here. Shifting larger shares of students to therapy. Put bluntly, we have to consider whether it's appropriate to trade student and employee rights and the public accountability, meaning, you know, disclosure of records, getting access to the financial records of the companies that are financing the construction of charter schools is one of the, and land acquisition even under these, and they're under these federally subsidized, they're under these subsidized new market tax credit programs that they're doing this urban redevelopment. Getting access to the financial records of the complicated network of private companies financing the development of these properties is impossible because they are not government entities. You can complain all you want about gaining access to information from your government, but you know, I've still found it much easier to get teacher contracts, salary data, all sorts of other stuff from government entities that are often managed on a publicly accessible government website than to get the same stuff out of charter management. One of my friends, Gary Murin, who does a lot of national studies on this stuff, just gave up on collecting teacher contractual agreements from charter management. Maybe he hasn't spoken, but Gary, if you're out there, come. We're streaming. I'll send Gary an email follow-up. Further, we must consider whether it's appropriate that these trade-offs are far more likely to occur for some kids than others. Look at this chart market shares. And this is, to me, a serious public policy question. There, the trade-offs we can't ignore. They are not benign. The trade-offs must be made clearer to those making the choice. That's the other thing that's really been bugging the heck out of me is we don't tell people, we don't tell parents that when they engage in this relationship with a private charter management organization, that this may result in the loss of certain rights for their kids. We don't tell that when teachers are interviewing. We don't, you know, people don't know that they're making, and a lot of people make naive decisions anyway about these things. But you know, the rhetoric has become so strong around it that it's a public school like the other. It just happens to be a great school that is a school of choice. Well, it's public in some respects and private in others, and the respects within which it's private are important to at least consider. Right? They're not the kiss of death. I mean, you look at salary data on the major New York City charter school chains, and if you're in the 5th, 10th year of teaching and working in a KIP or a uncommon school or something like that, you're making 20 to 30% more than a New York City public school teacher in the same neighborhood. You can get some, and sometimes you get a really great job, like I had once in just a purely private school. But there are trade-offs, and we have to be open about those trade-offs. And there are big ethical questions in pushing this as a major public policy platform. So that's my punchline. And that's where I'll end it. And, my stack keeps want to go back to numbers on the wall. We can do some of that, or we can just kind of kick it around a little bit. Yeah.
I have 2 questions.
Yeah.
One, I'm just curious to know where Rutgers would sit on that big chart. I know it's mostly public schools, and that's a stupid question.
As a university?
Yeah, Rutgers would sit on.
Yeah, college and university systems are very different, but more toward the public end of the spectrum. Although our boards of, I'd have to look at New Jersey state law regarding, although I think all of our various boards are governed under the same kind of open media and records and all of that, that if you parse each piece of the legal arguments I've got so far, that we're pretty hard in. But even in New Jersey, even the charter school structure, just New Jersey has generally defined its public entities and its private entities that do the public work as more public than private.
And my second question was the school that the controversial charter school that's going on very low that's part of that now is aiming for these funds. Like, kind of, where does is there a general way that that might fit into your diet?
Well, it's an interest.
There's a charter school that there's a bit of a controversy about that's been applying for funding and wants to it started in kind of bars, now it's trying to be in Brunswick. Don't know the extent of where that whole thing sits and whether it's even.
Yeah, it's interesting because like in New Jersey we do have a process that allows the approval to be governed by the state at the state level by the Department of Ed, and we don't have a provision that requires approval or agreement by the local district. So once the approval is granted and the school is established, we then also, we also have a legal structure that permits the state to require the passing forward of funds. Had you been in, if this was in Georgia 3 or 4 years ago, you had a case, right? But it's conceivable that the state can create this school, and that the district can be obligated to pass forward, which is why, it's the other thing is that every policy decision doesn't end up coming down to, and fighting against everything doesn't come down to having, the best legal strategy. Oftentimes it's having the best political strategy. And even the biggest legal cases are oftentimes about political strategy, not legal strategy, because the legal arguments are so narrow, and you just don't have necessarily, kick around a few people and see what they thought lately, but I don't think there's a tight legal angle. I think that the structure of authorizing in New Jersey permits it to happen. Well, that's the fun piece. That has yet to be successfully litigated in other cases where charters with a cultural emphasis that is clearly a religious emphasis have been there really haven't been any challenges that have gone far on the basis of a government endorsement, or kind of a First Amendment challenge of government endorsement of religion by virtue of authorizing a school that is teaching a religion under another name. So, yeah, I'm not sure you get it legally that way, politically legally.
So I have a question for Florence on that a little bit. When the state approves charters, do they actually look at the kinds of potential?
Nobody knows what they look at. Nobody knows. In fact, the last time, I don't know what they did this past time, but the time before that when they approved charters, they just called in a random group of really vocally pro-charter individuals to sit and discuss the applications because they claimed they lacked their own internal capacity to review them. So they brought in an interesting group of private citizens to help review the apps. And they did not release, I don't think, I think they were requested to release, but did not release many of the details as to what informed their final decision. We've got a few people now who've been denied 3 or 4 times in a row who are trying to challenge them, which should then bring out what they did, because they would have a due process claim, at least to have the process vetted to see what was due in the denial of the application. Right? They're not going to release the details behind their decisions unless it comes down to a legal. maybe using private citizens to get the applications is also, I'm not sure, I'd have to go back and see whether they argue that the deliberations among private citizens are not subject to open meeting. The way it works. I'll go to you in a second.
Dean DeLisi is watching remotely and he has a comment.
Yes. Excellent.
Many U.S. citizens seem willing to give up privacy rights in the name of national security. Looks like promise of better education through charters provides a similar context for forfeiting rights.
As long as we're open with that. I mean, that's my main point, right? That as long as we discuss what the trade-offs are, and as long as we don't, through concerted public policy, disproportionately force those trade-offs on some populations versus others. I think my concern here is that we're not discussing the trade-offs. We're just assuming anything that might be traded off to be benign, right? That it's not. So, and I guess I also don't know how often the average public citizen considers what the legal rights trade-offs to them might be as a function of national security policy. Right? We don't consider it until they start, raising these big issues in the news about, wiretapping, reading emails, and stuff like that. And then after that, we get to ask ourselves, okay, are we still good with that? Right? So kind of what I'm saying here is, well, let's think about it in advance. We got some court cases that are illustrative out there. And if you've considered these possibilities and you still think, yeah, these are reasonable choices to make available, then that's fine. As long as we're openly considering the trade-offs and as long as we are not, through kind of concerted public policy, pushing those trade-offs disproportionately off on some more than others. Right, so that's where I would come down. We're all terrible at considering trade-offs. We pick the one index that we want to go with as the benefit. And we can get a philosophical angle on that from the chair, Jim. Teleological was it versus the whatever, but I'm going to go to Steve.
One of the many risks to your host traditional school district would be a charter school going out of business. I imagine consistent with other kind of charter school regulations. To what extent have you found that there is some kind of notice period, advance notice of a charter school having to notice it's going to close its doors? How much in advance does it have to give notice, or do they normally give? But then all those students have the right to go back to public schools.
Right. That's a really cool question. It's going to vary by state regulations, which in most cases would have been developed reactionary, right? That there would have been a particularly catastrophic or problematic last-minute charter closure, and the state, in hindsight, then figures out, okay, how are we going to handle this in the future? Being that you're one of my doctoral students, I know who I can assign to explore that. But you're probably already ahead of me on that one. So, yeah, I think, I don't know. We've had a few kind of collapses in New Jersey. I don't know that there have been significant regulatory changes as a result.
Okay, just thank you. I think we're and I want to thank thank GSEC for sponsoring all of this. So thank you very much to GSEC. And the programs announced on the website.
You forgot to thank the dean.
And thank you to the dean for sponsoring all of us and for your questions.
Watch it.
I have to watch it. The first few. Next week, Dr. Zhang will be presenting, so please come out and have a good week.